Yes, ma'am.
Yeah, okay. So, good afternoon, all faculty members who are the participants in this faculty development program. And myself, I'm Dr. A. Franklin Richla from Holy Cross College, Autonomous, Nagarkoil. And my college is in down south of Tamil Nadu in Kanyakumari district. To say a few words about my college was established in the year 1965 as the first women college in Nagarkoil, in Kanyakumari district. And we are accredited by NAC in the fourth cycle, and our rating is A plus. And by the month of May or June, we'll be going for the next cycle too. And I invite all the faculty members who are participating in this program to visit our college. And now I'll share my PPT. And please, the organizers, kindly tell me whether my PPT is visible to you.
Yes, ma'am. The PPT is visible.
Yeah, thank you. And again, I welcome you all for the 2 days national level FTP on IPR, entrepreneurship development and startups. As the first day in the session is titled as Basics of IPR. As faculties, we know more about IPR, intellectual property rights. And in this session, we are going to just brush up whatever we know already, or we can take it in such a way we are recalling the information whatever we know on the basic elements and the components of intellectual property rights. And let me start the quote given by Brian Tracy. Commit yourself to lifelong learning. The most valuable asset you will ever have is your mind and what you put into it. So the learning outcomes of today's faculty development program will be like this. At the end of the session, you'll be able to know the meaning and nature of IP, meaning of IPR, need for legal protection of IP, the purpose, advantages, and disadvantages of IPR, the various components of IPR like copyright, patent, trademark, and service mark, industrial design, geographical indications, trade secrets, and the first lay talks about the meaning of IP, that is intellectual property. So, intellectual property is an intangible property, intangible science. It cannot be seen or it cannot be felt. So, where it comes from? That's the question when we ask about the meaning of IP. This intellectual property comes from the human minds. So it's the creation of human minds which came into existence through the intelligence of human beings. And otherwise, if you say it's a creation of the mind or the product of the human intellect, maybe the images, the artistic work, the literary, the names, logos, symbols, and especially it should be used for commercialization. Like we should use it in the field of commerce. And the nature of IP talks about, unlike other properties, for example, if you take the movable and immovable property, whatever we are possessing in our life, like car, house, land, jewelry, etc., this IP cannot be felt, cannot be seen, or it cannot touch the intellectual property. So the main nature or the characteristics of IP is its intangibility. And also the property right can be inherited. For example, I tell you in this way. If the intellectual property created by Mr. A can be inherited and transferred to his son, Mr. B, and Mr. B can again transfer or inherit his intellectual property to his son C. So it can be inherited. It can be bought from one person to another person. It can be sold and it can be gifted. it can be gifted to some other person, it can be licensed, it can be entrusted, or even it can be pledged. And the major thing is this IP always subject to the doctrine of exhaustion. Exhaustion in the sense, after a certain period of time, this IP should be either renewed or it should be licensed or it will come to an end. So IP comes under the doctrine of exhaustion. And now comes to IPR. The title is Basics of IPR. So we'll see the meaning and the nature of IPR first. And the meaning is IPR is nothing but the abbreviation of intellectual property rights, the rights which relates to the ownership of intellectual property. For example, if I am holding an intellectual property, whatever rights conferred to that particular intellectual property are called as intellectual property rights. The bundle of rights which is conferred by the law of India prevailing at present on a creator or the owner or the inventor of intellectual property are comprised as intellectual property rights. This rights also associated with the intangible property. That is why it is called as IP, intellectual property rights. May be owned by a person or an association of persons, a company, or the interested persons. And it can also be protected against the usage without the consent of the creator or the inventor. For example, to say, if myself, I am the creator of particular intellectual property, no one is supposed to use my intellectual property without due consent of myself. That is given is protected against the usage. And coming to the nature of intellectual property rights, it aims to protect the creations of human intellect. That means if a human being is creating an intellectual property, they have to protect it. So this intellectual property acts mainly aims to protect the creations of or the invention of a human intellect. Only the creator can take all the benefits from their own creations. And it also protects the interest of the creators by rewarding the mental labor, whatever resources they are investing to create the intellectual property, they can get the reward out of their own creations. And it also allows them to retain the property rights. Unlike other tangible rights, whatever rights we are having, we can keep hold all the rights for this intellectual property also. And the need for legal protection of intellectual property. Here comes a question why we should protect the intellectual property. Why can't we just leave it like this? If I am having an intellectual property, why I should put the intellectual property under the umbrella of law? Here I have given you listed some points, but there are many need coming under intellectual property, but I have listed very few. First one is to encourage inventions and creations, to bring more and more inventions, to bring more and more creations, innovations, novelty, which ultimately touch the promotion of social, economical, scientific, and the cultural development of the entire society. And second one is why we should protect our intellectual property is we want to protect our property from third parties. If a third party is using our intellectual property without our consent, you may sue that party. So for that, you have to get legal protection of your own intellectual property. And third one talks about the recognition. So whatever efforts the creators are putting, they should be rewarded. If only the legal protection is there, they feel okay. I have protected my property. For example, if you buy a land, you will always fence the land because you want to avoid the trespasses, right? Like that. It should give a proper recognition to the creator under law. And it also prevents the infringement of proprietary rights. If you have intellectual property, you are the proprietor of the particular intellectual property. So nobody can infringe your property without your consent. Unauthorized usage can be terminated or curbed. And the last point talks about to encourage the investment, skill, time, finance, and other resources into innovation activities. So, whatever investment skills, or finance, or the sacrifices, or the other resources which were rented by the owners should be converted as innovation activities, which is beneficial to the welfare of the human beings in that society. The purpose of IPR is the main and most uttermost purpose is to reward the human intellect. So, for example, we are all faculties. We have so much of students. For example, when you drop a pen, immediately student will come and take up the pen and give it to you. So immediately what will we say? We say thank you, right? So that's a small appreciation given to the particular student. That like that, the human intellect, whatever I'm using to create an intellectual property should be rewarded by providing an exclusive rights. Exclusive in the sense the entire rights. The creator only can enjoy whatever rights abided by the law to a particular intellectual property. Over the inventions, maybe artistic work, maybe literary work or choreography work, whatever IP they are having, they have the exclusive rights. And next, we talk about the advantages and disadvantages of intellectual property rights. So, a coin has two sides, likewise. Every concept has advantages and disadvantages. If benefits are there, definitely there will be drawbacks also. Likewise, this intellectual property rights also have advantages and disadvantages. Coming to advantages, first point talks about the competitive advantage. If you want to win the advantage, or if you want to show your difference, your peculiarism, or your specialization from that of your competitors, this intellectual property rights should be a must one. So, so obtaining the intellectual property right is a must for each and every company. It's the lifeblood of every company. And IPR also enhances the value of your company. If you say, I have this, and this many IPR, that is intellectual property rights, maybe patent, maybe copyright, or whatever you are having, it adds values to your business. This opens the avenues for collaborations with some other companies or the MNCs, or even from the FTAs, foreign direct investments also, which ultimately generate the income by entering into licensing agreements also. And the third one is it attracts more clients for your business, and it creates the brand value for your business. And coming to the disadvantages, to obtain IPR, you have to spend cost like legal cost, proprietary cost, and other fees, whatever the government is prescribing, you have to pay for it. And second one is, although you have protected your intellectual property, still many people may use your intellectual property in some or the other way. So, protecting or curbing the copying and unauthorized use of your work is another great difficulty you will face. And the third one is IP rights are not absolute. In the sense, how I'm telling this is, there are certain limitations which the government is imposing through their law as a limited period of protection, or after a certain period of time, you should go for compulsory licensing. So these are the disadvantages we are having under intellectual property rights. And the main part of today's session is the faculty development program is the components of intellectual property rights. So here I have listed few components of intellectual property rights like copyright, patents, trademarks and service marks, industrial designs, geographical indications, and trade secrets. So the first one talks about the copyright. So copyright is an exclusive right which is given to the creators or authors for their literary and artistic work. and it is also called as literary right or author's right. This copyright helps you to prevent your material, that is, maybe your paper, research paper, or maybe your thesis from others. They can't copy or they can't publish your own material in their own publications. So it protects you from copying and unauthorized publishing of your own work. And here I have given some pictures in which you can get copyright. For books, you can get copyright, artistic work, for music, for cinemas, and etc. And copyright protects the following two rights of the author. So one is economic rights and another one is moral rights. So economic rights talks about the right of the owner to derive financial benefit out of his own creation. So if a person, sometimes we might have seen when you download a particular textbook, or if you want to get a well premier journal papers, sometimes you can see a small icon, a locked icon. That is, if you click that icon, you will be directed to the gateway of any payment. So for this, if you pay the amount, you can access the particular journal or the particular research paper. So in some areas, the author who obtained the copyright may get financial benefit out of his own creation. And second one is moral rights. Moral rights are the other rights like the reputation of the author and his integrity, which is not economic interest of the author. And coming to the term of copyright, the copyright can be extended throughout the lifetime of the author, and after his death, it can be more again 60 years. And what kind of works can be protected under this copyright? As we have seen the picture, many more are there. Maybe literary works like novels, plays, poems, stories, verses, and taglines, newspaper articles, etc., and computer programs, databases, and films, musics, and choreography, artistic work like pencil drawing, paintings, photographs, sculptures, architecture, advertisement, maps, and technical drawings also comes under this copyright. And next, we are going to learn about patents. So, patents are the exclusive right which is granted for an invention or the innovation, which may be a product or a method or a process or improvement of a existing article. It's a right of monopoly, monopoly in the sense single person. It can be granted to a person who has invented the particular, maybe a machine, maybe a process, maybe a method of production, or an existing product can be improved for its usage. Like to say, example, if I want to quote, if you take this mobile phones, the additional features, whatever you are adding to your mobile phone, can also be patented. And for the inventions which are having industrial and commercial values can also be patented. And the patent owner can sell his patent, either he go for production or he can sell or he can license to others to exploit the same. Exploit in the sense he can allow others to use his invention. And the term for patent is 20 years from the date of application. And the patent office is providing this patent according to the early date. I mean, whoever is applying for the patent, the first person, the first come, first in, the first person who is applying first will get the patent. And these are the examples for patents. The first picture is the front face of a vehicle wheel. Second one is shoe upper. Third one is socks. And fourth one is eyeglasses. Fifth one is golf cart. And the fifth one is gamut. These are the things, general things, they are patented. And the kinds of protection given to patent holder. So what are the protection this patent holder can have. First one is the patent owner possesses the exclusive right to prevent others from commercially exploiting the patented invention. If you are getting a patent to commercialize your product, you are the monopoly to sell the particular product. No others can buy or sell or import. They can't do anything. The patented product, what you have got, the protection. So it is an exclusive right. All the rights on the particular property belongs to you only. And third parties are prevented from manufacturing. So the other parties, other than you, no one is allowed to manufacture, no one is allowed to use, distribute, or sell the patented invention or the product without the consent of the patent owner. And the next one is trademarks and service marks. Trademarks is nothing but a symbol that is used to distinguish the goods of one company from the other company. So a symbol or a numerical or something, a small logo may also come under trademark. So it consists of a single letter, maybe a logo, brand, slogan, mascot, symbol, design, or numerals, or the shape, or the packaging. Everything comes under this trademark. And trademark gives a distinctiveness, a hallmark of your product. So, if you are going to purchase gold, definitely we'll check whether there is a sign of hallmark. There is a seal of hallmark, right? Likewise, this trademark plays a vital role in your product. And trademark used in connection with services such as tourism, um, medical, and education, banking, insurance are called as service marks. And there are 45 classes of trademarks are there. Out of 45, 34 classes are for products and 11 classes for services. And the trade for trademark is 10 years and it can be further renewed or can be used for indefinite also. And here are a few examples of trademarks. First one is the Apple logo, second one is McDonald's, H&M, and Gucci. And purpose of a trademark, why we should go for trademark. So as I told you before, trademark is a symbol that identifies a product and its source, and it differentiates your product from your competitor product, and it also reflects the goodwill of your business. So if I'm having a trademark on my product, definitely it will increase the reputation of my own product and also assures the consumer about the established quality of a product. If you're having a trademark product, definitely the quality of the product will be of standard, not a deteriorated one. And a registered trademark provides legal protection to the brand. So that my brand will be legally protected, will be under the umbrella of the law. And it helps to establish a dedicated consumer base by preventing others from imitating my brand. So once you go for trademark, no one can imitate your product, maybe the shape of your product or whatever you're using in your product. No one can imitate you. And industrial designs. So the next one is industrial designs. Industrial designs are the ornamental or visual aspects of an article. Ornamental in the sense decorative areas are it can be seen by your eyes. That is industrial. That comes under industrial designs. It does not cover the utility or the functionality of your product. It provides legal protection to the creative originality of an industrial design to prevent others from copying your designs. And it consists of three-dimensional features or two-dimensional features like the shape of an article, maybe a line, maybe a pattern, color, or the combination of colors, etc. And these are the few examples for industrial designs. First one is the cutlery sets, which we use in our dining table. and it is decorated. It looks little different from the usual one. And second one is the Coca-Cola bottle. So no one can copy the shape of the bottle or the writings or the wordings, whatever engraved on the bottle, they cannot copy. And type of protection provided by industrial designs. So what are the protections you will get when you go for industrial design? So it reserves the right to prevent others from manufacturing. So no one can manufacture, no one can sell or import or bear or embody a design for which you have gone for industrial design. And what kind of products can be protected against this and protected under industrial design? The product of industry and handicraft items, household goods, lighting equipments, jewelry, electronic devices, textiles, etc. And next we are going to learn about geographical indications. So these geographical indications used to identify goods having a specific geographical origin. The product will definitely have a touch of its origin from which place it has been created. So essentially it is attributable to their geographical origin. These geographical indications may be used in the foodstuffs, agriculture products, wine, industrial products, and handicrafts. So here I have given three pictures and I'll tell you more about it. And the first one is Darjeeling tea. So the tea became famous, or the tea, the origin of tea is Darjeeling. So that tea, if you say tea, immediately will have the thought of Darjeeling. And the second one is Madurai Mallike. This is from my place in the sense my state. This Madurai, this is a flower which ladies used to wear on their hair. So this Mallike, this jasmine, so this flower is a special species which is grown in the Madurai district. And third one is Tirunelveli Alva. So immediately we say the word Tirunelveli, so everyone will remember that Alva because this Tirunelveli Alva has become the origin of this Alva has originated from Tirunelveli. And the next few examples are Ceylon cinnamon and Himachal basmati and Malabar black pepper and Kashmir saffron. And trade secrets. The last component of IPR is trade secret. So, what is trade secret? The rights which whatever we are having as a confidential business information which can be commercialized comes under trade secrets. For example, if I tell you the components, for example, Coca-Cola, if you take the components, whatever they are mixing to make Coca-Cola is the best example for trade secret. It may include designs, drawings, plans, promotional strategies, marketing strategies, research and development informations, etc. In order to qualify as a trade secret, the information or the trade or business information, what we are considering as a trade secret, should have commercial value. And so far we have discussed at the national level. So I want to put a particular organization which talks about the intellectual property worldwide. So I have taken this slide. I'll tell you as a summary. This World Intellectual Property Organization has been established in the year 1967, 14th of July. It's a global forum for intellectual property which provides services with trade policies, which provides information, and all the cooperation activities also held here. And the aim of this WIPO is to develop an effective and balanced international intellectual property system, which thereby encourages the innovations and creativity for the benefit of all. So WIPO is having 193 member states. Out of 193, India is also one of the members of WIPO. India has joined WIPO in the year 1975. And the objectives of WIPO are It promotes the intellectual property protection around the world. How they are doing it to state cooperation and partnership with international organizations. It also harmonizes national intellectual property legislation and the procedures to be followed for intellectual property. And it also provides services with regard to international applications for intellectual property rights. For example, we are in India. If I want to file a patent in USA or Australia, so this WIPO can help me to apply in USA or Australia, and whichever country I wanted to apply, they render the hands for applying IPR. And also it exchanges information on intellectual property. And it also provides legal and technical assistance concerning intellectual property to developing and other countries. And it also facilitates the resolution of private intellectual property disputes. If some disputes arise, this WIPO will help them to resolve the disputes arised. And it also marshal information technology by storing your information, accessing your information, and using valuable intellectual property information. Hope you have enjoyed this session, and we have come to the concluding remarks. So IPR is a very strong protection tool to the investment, time, money, and the effort which is invested by the investor and creator of the intellectual property. It is a valuable asset as we think about the movable and immovable property. The same. It is also this IP is also very valuable asset since it provides a competitive advantage of your business, which shows the difference from your competitors. And it also gives legal rights which prohibit others from using your intellectual property either for commercial purpose without your consent of the IP rights holder. Thank you all. And stop sharing. And if any of you are having any clarifications or doubts, kindly feel free to ask me.